Morning, everyone. I'm Judge Jackie Powell, and we're in first appearance court. Today, I am going to be telling you whether I find probable cause based on these affidavits that I've already read, and then we'll talk about release conditions. Today is not your trial date, so I encourage you not to speak on the record about your case, especially for those of you who will be going to trial at a later date, because everything in this courtroom is being recorded and can be used against you at a later time. In the courtroom, I have with me the attorney from the State Attorney's Office, Mr. Eric Linder, and I have Mr. Goldberg from the Public Defender's Office, and over at the main jail, who's there? Okay, and over at the main jail, we have Attorney Corey Hill. In the courtroom, I also have confinement status and pretrial supervision services and the clerk of court. What that means is that the attorneys from the Public Defender's Office, for those of you who are being represented by the Public Defender's Office, speak to your attorney. Those of you at the main jail, speak to the attorney, and when I call your name and you come up, you can, before you say anything, let the attorney know so that you can see if it's okay for you to talk on the record. For those of you who have private counsel, those attorneys often appear in the courtroom, and if they're here, they will also speak on your behalf. Some of you may be able to resolve your cases today. It's only those of you with misdemeanor cases, and, depending on the situation. And if there is an offer, we will talk about that when you come up. So I am going to, I'm sorry, Mr. Weeks, what page was your case on? Okay, so I'm going to, and I'm also, if there's anyone else in the courtroom, you need to sign in so that we can locate your paperwork. And if the Public Defender's Office represents you and you've already spoken to them, then we may be able to get you out of here a little bit sooner. Okay, so we will start this morning with Ricky McInnes, who's on page 23. Is Mr. McInnes?
Judge, I don't see any issues with probable cause in this particular case. I talked to Mr. Linder. I think we both agreed that a $5,000 bond is appropriate. So I'd be asking along with Mr. Linder, that $5,000.
That is true, Your Honor. Just $5,000 bond and no contact with Jesse Bailey.
Okay. All right, Mr. McInnes, good morning. You're before the court today for one count of felony battery. You're before the court this morning for one count of felony battery, and I do find probable cause. So your bond, as you've heard, will be set at $5,000, and then there's no contact with the victim in this case until further order of the court. Okay?
Thank you, Judge.
You're welcome.
Have a good day.
Sure.
Morning, how are you? All right, Amy Olshansky.
Judge, she's up in North Broward, and
What are these, ad charges? She was here yesterday.
it's the Mr. Linder and I, North Broward.
We're not sure. The one thing, well,
It appears to be the same probable cause affidavit as yesterday, same fact pattern and everything.
I think the one thing Mr. Goldberg and I are sure about is we do have no problem just RORing in these counts. I think the bonds you said yesterday cover all the allegations.
Okay.
Yeah.
All right. All right, Ms. Olshansky, sometimes these things happen, but I know you were here yesterday, so we will ROR you on all the counts that have been presented today, and the bonds that were set yesterday are still in place, okay?
Correct.
Well, I can't leave unless I'm bonded out, is that correct?
That's correct.
Even though this is my
We're
first
not
time.
we're
I'm-
not going to talk about
All
the
right,
facts
you
of the
can
case
speak
at all.
to your attorney about anything further, okay?
Will you contact me? How are you going to get in contact with me?
Ms. Olshansky, I'll call Robin and Bonnie like you asked me to do, and we'll be in
Please,
touch.
sir.
Okay.
Okay,
Thank
thank
you.
you very much. Yeah.
There's two cases of child abuse, because it is dated to the same PC, and I don't think they realize that if they put the initiative, there's 3 counts of battery and the counts of corrupt were already done, and then they added 2 child abuse.
Yeah, but
Oh, all right. So she's RR'd on those two counts. No, the bonds that were placed yesterday are still in place. And now I'm assuming those child abuse counts were not on the PC yesterday?
they weren't, Your Honor, but you said bonds on you said bond on 3 counts of battery, which
Right.
included the 2 children, so I figured you already considered
Okay,
the battery.
yeah, all right.
Yeah, again, she's not being ROR'd outright, the bonds
No.
that you set
Yeah,
yesterday.
exactly.
Okay,
Yeah,
all right.
thank you, Judge.
You're welcome. Hip Nguyen,
Judge, he's in the main jail, but I've been advised that he has private counsel. I don't
and
know.
does he need a Vietnamese interpreter?
Mr.
Is it a
Newman?
he? I think, based on the affidavit that I read, I think he needs a Vietnamese interpreter.
It's a female, Your Honor.
I'm sorry,
Sorry,
she
Miss
needs a,
Newman, I'm sorry.
so, can you see if we can get an interpreter?
Yeah, I'll call up.
Last time we were able to get one, so,
Yeah.
all right, so we'll recall that. All right. On page 7, we have, no, page 4, Darius Watts. Did somebody sign in on Watts? Yes or no? Well, okay. All right, Mr. Watts, who's on page 4, Mr. Watts, you're before the court for 1 count of felony battery. And I do find probable cause, because the parties wish to be heard as to bond.
Your Honor, based on the allegations, I'd be requesting a $5,000 bond and no victim contact.
Good morning, ma'am. How are you?
Good.
Who are you?
I'm Maya Coney. I'm the victim that was involved.
Okay. And is there something you wanted to let me know?
Yes, I just
Not
want-
about the case, all right? Today's not the trial, so we're not talking about the case. I have to make a determination as to the bond, so you can let me know about that.
Okay, well, that is my brother, and I didn't want it to get this far, but I mean, sometimes you gotta learn. You do it to me, you'll do it to anybody. That's just,
When you say sometimes you gotta learn, do you mean you?
no.
Oh, okay. All right, is the family, are you posting bond? Okay, all right.
Judge, if I may be heard, please?
Yes,
Thank you. Unfortunately, at this time, the bond that's been requested by the state attorney is not something that Mr. Watts would be able to financially post.
No, I would.
He's not working right now due to he's having seizures, so unfortunately, he's not able to work. If we could just hold on 1 second. Judge, we'd ask if the court would be inclined, Mr. Watts just indicated if that bond was just reduced somewhat to maybe $2,500 to give the court assurances. He would have somewhere else to live if the court was to order no contact with his sister. He can reside with his aunt, to negate going back into the home with the sister at this time, but we would be requesting a $2,500 bond.
all right, I do find probable cause. I'll impose a bond of $2,500, no victim contact
$250, right?
until further order of the court.
Get out of here with $250, okay? Thank you.
All right, good luck, sir.
Your Honor,
Get out of here.
Yes, ma'am.
I want to request a
Down the
restraining
road.
order.
See how that works?
Well, you have to, I have ordered a no victim contact, and they will have to talk to you about getting a restraining order.
Your Honor, our victim advocate will explain to her
Okay.
what she needs to do to obtain a restraining order.
All right. Violetta Boyley on page 7.
Judge, good morning. Phil Lorenzo. I'm here on behalf
Hi, the
of
counsel.
Mrs. Boyley.
Good morning, Mr. Duranza.
And, Your Honor?
Yes.
Before the court makes any PC determination, I just have some information.
Okay,
I reviewed the case of Mr. Dorenzo this morning. On the booking, and I suspect on your findings, it says felony battery with a common battery.
Yes,
It was charged as a misdemeanor battery.
okay,
And I believe also, while the battery isn't specifically referred to in the PC affidavit that's attached, I showed Mr. Dorenzo a supplemental report which addresses the battery charge. I believe we have an agreement as to bond release conditions if acceptable to the court.
okay,
It would be a $500 bond on each count, total bond of $1,000. No contact with the alleged victim, Lawrence Holzer.
That's correct, Judge, if that's acceptable to the court.
all right, so misdemeanor battery on count 2. All right. All right, Ms. Violetta, just to let you know that you're before the court today for, count 1 is criminal mischief. On count 2, I am making a finding for misdemeanor battery. I do find probable cause as to both, counts. And, your bonds will be $500 on each count and no victim contact until further order of the court.
Thank you, Judge.
You're welcome, Mr. Dorenzo. Good to see you.
You too.
Thank you. Done.
Okay, on page 11, we have George Trodella. Mr. McLaurin.
It's the main jail, making his way to the podium.
Daniel Slack.
Mr. Trodella, good morning, sir.
Morning.
You're before the court for a municipal ordinance matter, possession of an open container, and I do find probable cause. What does Mr. Trodella wish to do?
Judge, in speaking with Mr. Trudella earlier this morning, he wishes to resolve this matter.
Okay. Mr. Trodella is not a candidate for community court.
Judge, I wouldn't know, I would need to know his prior record. We've sent a couple of people over there only to have them sent back to criminal court.
Oh, okay. So I think I've seen Mr. Trodella before, so. All right, Mr. Trodella, if you wish to resolve your case, it'll be adjudication and time served. Do you wish to resolve your case with that, sir?
Yes, ma'am.
All right, Mr. Trodella, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay,
Yes.
you can put your hand down. And I just need to know if you understand everything that's going on here today.
Yes, I do.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, that by taking a plea it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given, sentence you to adjudication and time served. Good luck, sir.
Thank you.
Thank you, Judge.
You're welcome. Yolanda Taylor. Is Ms. Taylor at North Broward?
Main jail.
All right, Ms. Taylor, you're before the court today for count 1 is a misdemeanor capias. Count 2 is a traffic capias. Count 3 is a felony violation of probation. It's a no bond hold. Count 1 is not for magistrate, so I do find probable cause. Count 1 is not for magistrate. Count 3 is a no bond hold. On count 2, there's a $1,000 bond. You should be appearing before your division judge tomorrow at 9:45. Good luck, ma'am.
Thank you.
Okay.
Thank you.
Antonio Ramirez Oliva.
Hiring private? Yeah. Change his mind? Okay. Judge, this individual's hiring private counsel.
Okay. Mr. Oliva, good morning, sir. Have you already spoken to a private attorney?
Not yet.
Is your family attempting to hire an attorney?
I will do it myself.
Okay, so you understand that even at this stage of the proceedings, that you are entitled to representation and that you have the Office of the Public Defender's Office there. So are you declining their services at this time?
I'm not. I mean, at the moment, he can help me.
All right, well, then they'll need a few minutes to speak with you.
Judge, I did have the opportunity to speak with him this morning.
Okay.
Prior to knowing he was hiring private counsel.
Okay,
Give me a moment, please. What's your last name again? What's your last name?
Oliva? Ramirez?
Judge, what page of the docket is he on?
I don't know, I really don't.
Thank you. Judge, at this time, in speaking with Mr. Oliva, he's 19 years of age. He was educated here in our county. He does reside here in Broward County as well. He lives with his mother. He is requesting at this time, if possible, to post a $2,500 bond on count 1 and a $2,500 bond on count 2. The allegation is against his wife, but he is going to be residing with his mom, and he said his wife will no longer be in that home.
Your Honor, I also would be asking for a $2,500 bond on the false imprisonment. On the aggravated battery, I'm going to be asking for a $10,000 bond based on the level of violence and the injuries suffered by the defendant's wife. Bruising and swelling to her face, a deep laceration with swelling above her left eye, scratches to both of her arms, and bruising to her left hand. She advised law enforcement that she is in fear for her life with respect to Mr. Ramirez Oliva.
And Judge, if I could say one more thing, the state attorney indicated swelling, cuts, and lacerations. That does not rise to the level of aggravated battery. That's misdemeanor battery. Those are cuts and bruises. Aggravated battery needs to be great bodily harm or permanent disfigurement. Those things, according to the state attorney, were not listed in the probable cause affidavit. Therefore, I would object to probable cause on aggravated battery and ask the court to find PC for misdemeanor battery.
Respectfully, Mr. Hill, I don't believe has seen a copy of the PC. I didn't mention, because the court's already seen this, that he also allegedly struck her over her left eye with her cell phone, which I believe would constitute aggravated battery.
All right, Mr. Oliva, you're before the court for one count of aggravated battery causing harm, bodily harm. Count 2 is a false imprisonment. I do find probable cause as to both those counts. As to count 1, I am going to impose a bond of $5,000. On count 2, it'll be $2,500. No victim contact until further of the order of the court.
You okay with him?
Okay, good luck, sir. Jamie Baderna
Judge, we need a Spanish interpreter, and one is on the way.
on Mr. Baderna.
Recall. Yep.
Okay, I'll recall Mr. Baderna when we have a Spanish interpreter. Thank you. Brenda Moore. Do we have Brenda Moore? Ms. Moore, you're before the court this morning. It's 3 traffic KPS counts. On the charges are driving under the influence, refusing to submit to blood test, and suspended driver's license. This is a KPS from February of 2012. The bonds attached to each count are $2,000, $1,000, and $1,000, and you should be before your division judge tomorrow at 8:30. I'm going to leave the bonds in place at this time, and you can, you'll be before your division judge tomorrow. Good luck, ma'am. Jennifer. I don't know if it's Jennifer Danko Cleary.
Yeah.
She's in North Broward. I spoke to her as to count 3, and she would like to resolve that matter as well. I do believe that she also wishes to resolve counts 1 and 2 as well. Count 3 is a trespass, a failure to appear at a calendar in September.
All right, Ms. Clary, you're before the court. There's 3 misdemeanor capious matters, and as your attorney indicated, it's open container, and trespassing.
Yes.
All right. It is my understanding that you wish to resolve your cases, those counts today.
Yes.
State, do you have an offer for Ms. Cleary
Yes, Judge, it'd be adjudication time served.
on all 3 counts?
Oh, just on the, count, 3.
Oh, the other one is municipal ordinance. All right, ma'am, if you wish to resolve your, these charges today, there'll be adjudication and time served on all 3 counts. Do you wish to accept that offer?
Yes, ma'am.
All right, please raise your right hand. Do you swear affirm to tell the truth?
Yes.
You can put your hand down. Do you understand the proceedings that you're in today?
Yes.
Do you need more time to speak with an attorney?
No.
Are you under the influence of drugs or alcohol?
No.
You understand you have the right to go to trial by taking a plea today. You're giving up that right.
Yes.
And have you ever been treated for mental or emotional illness?
I went to rehab for depression and alcohol.
Are you taking any medications today that would affect your decision-making?
No.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter today?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given. As to all 3 counts, your sentence will be adjudication and time served. Ma'am, do you need more time to pay your court costs?
Yes.
Okay, then I'll give you 6 months to do so. Good luck.
Thank you.
Shawanda McLaughlin.
Main jail. Judge, I don't have a PC objection. Oh,
No response here in the main jail.
oh, there you go.
Shawanda McLaughlin, okay, her bond has been posted is what I've been advised. All right, Kelly Temeki,
North Broward.
good morning. Mr. Mickey, you're before the court. Count 1 is resisting officer without violence. Count 2 is violation of felony pretrial. That count 2 is a no bond hold, and you will be before your division judge tomorrow. As to count 1, the bond is $100. I do find probable cause.
Judge, thank you. The only thing I would ask on this case is if we could have an order to allow us to take photos of Mr. Mickey.
Okay, I'll do that.
Thank you, Your Honor.
All right.
What
Amanda,
time? What time was my hearing?
Tomorrow morning, it's at 8:30.
Okay, thank you.
you're welcome. Amanda Herrig,
Yes,
Ms. Herrig, you're before the court for count 1, possession of heroin. Count 2, robbery with a firearm. Counts 3 and 4 are felony capious matters. Those are no bond holds and not for magistrate. I do find probable cause.
Judge, I do have I know we have an affidavit before the court on the robbery firearm, but I do have arguments as to that.
Okay.
As to the warrant, Judge, it appears, the allegations are that she, the alleged victim gave Ms. Herrig a ride to a location. They went to the location, and shortly thereafter, she went into a home, came out of a home, and then a gentleman came and pointed a firearm at the victim and took his possessions and vehicle. Shortly thereafter, they track the card and they pull the surveillance video. On the surveillance video, It just shows presumably the same gentleman. It doesn't show Miss Herrig at all. She is being charged with the robbery of the firearm on the affidavit. She's made no statements indicating that she was involved or that knew that the gentleman would be involved. The ID was made because there's a confidential source saying that the gentleman on the video is, the gentleman on the video is Richard Colon, and that Richard Colon knows Amanda Herrig. That is the only evidence before the court tying her to this crime at all, beyond just proximity to the crime that occurred. There's no evidence that she was involved in setting up this robbery firearm, and as a matter of fact, when he comes out, she left the scene. So, Judge, I would object to the court finding proof evident presumption great on the robbery firearm. If the court is going to overrule my objection and find proof evident, I would ask that you take this into consideration in setting a bond for her on count 2, because I don't believe that there's sufficient evidence before the court today indicating her involvement to charge her as a co-defendant in this robbery firearm. Or as a principal.
Your Honor, respectfully, I didn't request the court to find proof evident or presumption great, at least not yet. Frankly, I wasn't planning on it. I'm just asking the court to proceed with finding a probable cause, and noting that Judge Bailey did find probable cause when he signed the warrant, and I believe there is probable cause based on that. If the court does find probable cause, Your Honor, I would then proceed with making a bond request.
Okay, as to both counts, I do find probable cause, and I'll hear from the parties as to bond.
Your Honor, I'm going to be requesting $15,000 bond, pretrial with the GPS monitor. I would note that she already had an active capias at a drug court, and on the capias it notes that she eloped from treatment. She was ordered to be released from jail to, after being arrested on a failure to appear, Judge Tobin Singer ordered her to go to Florida House after 2 weeks of SAP. It appears that she took off from there, looking at the capias here. Now she's allegedly involved in a robbery firearm. So I do have concerns for safety of the community and her future appearance in court.
Judge, as the court's aware, she's being held no bond on those capiases. So regardless, she is going to be held no bond. She's lived here in South Florida for the last 10 years. She is not working. I spoke to a family member today who's going to try to help her, but he advised me that money's really tight, and so he's going to have a hard time posting any bond for her. Judge, I would just ask for, I don't think $15,000 is a bond that she's going to be able to afford realistically. I know she's got to see Tobin Singer on counts 3 and 4. Judge, I would just ask for a lower bond than that. I would ask for $3,000.
All right, I do find probable cause, and count 1, the bond is $1,000. Count 2 will be $7,500. Counts 3 and 4, no bond holds, and you'll be before your division judge tomorrow at 8:30.
Okay.
Your Honor, I would ask for an order of no victim contact.
No victim contact.
Okay, I don't know who the victim is because I wasn't aware of this. So Judge Powell, you're my judge
All right,
for
ma'am.
this.
I'm
You're
sorry?
my judge for this case?
No, I'm not.
Okay.
Yeah, you'll be going to a division judge on this case.
So for this, though, I have a bond of $1,000 and $7,500.
That's correct.
Okay, then I have 3 and 4 Tobin Singer, who I go to tomorrow.
That's right.
Okay, thank you, ma'am.
All right, good luck.
Thank you.
All right, on page 16, we have Osvaldo Amor, Mr. Attorney Z. Oh, good morning.
How are you?
Sorry.
I'm well.
Great.
All right. Mr. Amore, you're before the court for one count of aggravated battery. This is a 2016 incident.
Alfred Turner?
Yes, ma'am.
All right.
Judge, I've spoken with the state, subject to the court's approval, we'll stipulate to probable cause.
Hold on a moment. Mr. Amore, do me a favor, push the button. Thank you.
All right, so we'll stipulate to PC for the arrest, Your Honor. We would just, and I think the state and I were okay with the $10,000 bond, no victim contact.
Okay. Mr. Linder?
That is correct, Your Honor. I would also just be asking for no victim contact with David Sosa. Yes.
Okay. All right. Mr. Amore, you're before, I said that. You're before the court for aggravated battery. And you've heard from your attorney and the state attorney, so your bond will be $10,000 and no victim contact until further order of the court. Okay?
Yes, Your Honor.
All right. Good luck, sir.
Your parents are here.
Thank you.
Oh. You're welcome. Okay.
Which, the PC affidavit's in.
Jacqueline Polos,
No problem, Your Honor.
thank you. Ma'am, good morning. You're before the court for one count of grand theft. Count 2, false information given for pawn items. And count 3 is dealing in stolen property. I do find probable cause as to all 3 counts. Does the parties wish to be heard as to bond?
Judge, I'm not showing any criminal record for Ms. Polos at all. I don't know if the state has additional information, but if that's the case, I would ask for her to be released on her own recognizance, but I do have additional.
Okay.
I'm a little concerned about ties to the community. I see her first obtaining an ID card in the state of Florida late November of last year. An at-large address on the booking sheet with a Fort Lauderdale address. A Fort Lauderdale address on the PC affidavit that does not match the mailing address and residence that she listed when she obtained her ID card.
Okay, ma'am, do you have a local address?
Right now, I'm homeless. I came down for.
I'll take it, Ms. Polis. So she had been residing, getting some residential drug treatment, but I don't think she's there anymore. So what she said about not having a home is accurate. Judge, she's a certified paramedic. She had been working not as a paramedic while she's in treatment, but she's working. She had been working for the House of Hope Treatment Center. That's not where she had been residing, but she was working there in detox.
All right, so at this time, I don't know how we're going to ensure that Ms. Polos returns, comes back to court.
I mean,
If
can I
she's-
say something?
I am going to leave the bond in place, $1,000.
Would the court consider reducing the bond on count 3 to $1,000?
I don't have an objection to that, Judge.
I'll do that.
Thank you, Judge. Ms.
All right.
Polos, it's 3,000 total. I'll call your mom, okay?
Thank you.
You're welcome.
All right, Andrea Roja Castro. She's bonded. Thank you. Tiara Twitty.
Yes, ma'am.
Good morning.
Good morning.
Ma'am, you're before the court. Count 1 is burglary of an unoccupied dwelling, unarmed. Count 2 is petty theft. Counts 3, 4, and 5 are felony violation of probation. Those 3 counts are no bond holds. As to count 1 and 2, I do find probable cause, and I'll hear from the parties as to bond.
Judge, I don't have a PC objection, of course, as to count 1. I just want the court to note that though it's, I think, properly before the court as a burglary of an occupied dwelling, the allegations are that she removed a package from a front porch area. If it's attached, of course, that would constitute a burg dwelling, but it's not a traditional burglary of a dwelling as normally is before the court. Judge, that said, she's been here all of her life. She lives in Sunrise with her mom, and there's 2 children. She is not working, but she does sell hair. She's a hair supplier, and she normally makes between $700 and $900 a week. She is being held no bond on counts 3 through 5. So we would just ask for a standard bond for her on count 1. Count 2 is not, is no charge.
Your Honor, I'd be requesting a bond, $5,000, no return, no victim contact. I think that's pretty reasonable considering this involves someone's home. She's on probation out of Hillsborough County for burglary, and she's got an out-of-state hold that she's on probation out of another state for grand theft.
All right, I do find probable cause. As to count 1, I'm imposing a bond of $5,000.
And I never knew that I had
Ma'am, don't talk about your case. You'd have that discussion with your attorney. No victim contact and no return to this location.
Thank you, Judge.
Good luck, ma'am. Thank you. Desiree Sargent,
Main jail. Judge, she does have a bunch of family in the courtroom today, just so the court's aware. Mom is here, her sister's here, and her dad is here as well on her behalf.
okay. Ms. Sargent, you're before the court this morning for 1 count of aggravated battery with a deadly weapon, and count 2 is criminal mischief. I do find probable cause as to both counts, and I'll hear from the parties as to bond. Good morning, ma'am.
I'm Desiree's mom, and I'd like for Desiree to get a bond and come home so she can go to work. And
Judge, I have spoken to Miss Sargent. She is 18 years of age. She is gainfully employed. She does work at Pollo Tropical. She was educated here in the county. She's lived here her whole life. She lives with both her mother and father. The allegation is against a stranger. We were actually hoping if the court could maybe take some testimony from Mom about the financial situation. Miss Sargent indicated a $2,500 bond would be something that the family might be able to post. If not, in lieu, could we ask for pretrial release?
Okay.
And Your Honor, I would know Ms. Sargent has no criminal history, and because of that, Your Honor, I'm going to be requesting for a $5,000 bond based on the allegations, the level of violence alleged that she allegedly used a pair of scissors, causing a laceration to the victim's head that required the victim to be transported to the hospital. It would also be in an abundance of caution, requesting no victim contact, no return to this listed location, and nothing further, Your Honor.
Okay,
Judge, the only thing that I would also add, just in my conversation with the family, it appears that Ms. Sargent has sustained some injuries herself. Based on this, I believe that there's going to be a self-defense claim that's going to be raised here by the defense. It appears to be a stranger in the store. Obviously, we don't have all that information before the court today. And the family's very concerned as Ms. Sargent's getting ready to graduate high school and was hoping to move on to college, and they're very concerned that this arrest is going to compromise that. So, Judge, I'd also ask for a photo order so we can take her pictures.
all right, well, I will sign that order, but based on the affidavit that's been presented to me, I know this is what I have to take into consideration this morning. The allegations are pretty, it's pretty serious, and it's been said several times that this person is a stranger. That's gone across both sides of the aisle this morning. That a scissors was taken out in the middle of the store. So I have to take all of that into consideration. I can't just, I have to consider the safety of the community. All of that has to be taken into consideration. So, Mom, I know that you've indicated that the family's here. You've heard that the state is asking for a $5,000 bond. Do you wish to respond to that? How much money is the family able to afford?
if you could drop it down to 2,500.
Who does Ms. Sargent live with you?
Yes.
Okay. And how long is, what school does she attend? I'm sorry?
Dillard High School.
Okay. And how many days a week does she go to work?
5 days a week.
So every day after school, she goes to work?
Yes.
All right.
Said she should be back tomorrow, but we'll see.
I'm going to impose a bond of $2,500, but I'm also going to add standard pretrial supervision. No victim contact. And no return to this location. I believe it's called the Rainbow Store. No return to that location.
Thank you, Judge.
All right? You're
Thank you.
welcome. You're welcome, ma'am. All right, sir, just a moment. There was I know that Jamie Baderna needs a Spanish interpreter. Is there anyone else who needs a Spanish interpreter? Take it. All right, Jamie Baderna. He was there before. Jaime Narvaez Baderna. Okay. Just reaffirm to translate from Spanish to English and English to Spanish.
I do. Esteban Rojas.
Okay, Mr. Rojas, good morning.
Morning.
Mr. Baderna, good morning.
Señor Baderna, buenos días.
Mr. Baderna, you're before the court for one count of aggravated battery
Señor Baderna, usted está ante el tribunal
on a pregnant victim.
en cargo de lesiones agravadas en contra de una víctima embarazada.
Judge, I don't have a probable cause objection, but I want just the court to see on the PC that the refused to provide a statement and signed an affidavit declining prosecution.
All right,
Su señoría, no tengo el argumento con respecto a los indicios probables, sin embargo, cabe señalar que la supuesta víctima se rehusó a dar una declaración a la policía ni tampoco a firmar una declaración.
I do find probable cause.
Considero que existen indicios probables.
Your Honor, I'm going to be, Mr. Navarez Baderna has no criminal history.
Su señoría, el señor Narváez Baderna no tiene historial penal.
I am going to be requesting a $7,500 bond and no victim contact.
Voy a solicitar una fianza de $7,500 y que se le prohíba tener contacto con la supuesta víctima.
Based on the allegation that he grabbed his wife, who was 7 months pregnant, by the throat.
Dada la acusación de que agarró por el cuello a su esposa que tiene 7 meses de embarazo.
This caused visible scratch marks.
Lo cual causó rasguños visibles.
The children were present in the home when this occurred.
Los niños estaban presentes en la casa cuando esto ocurrió.
And Your Honor, I would just note, I don't know that the victim's refusal to give a statement or that she wished to sign decline prosecution.
Y su señoría, hasta donde yo sé, a mí no me consta que el hecho de que la víctima se haya rehusado a declarar y que ella haya dicho que no desea proceder con cargos en contra del acusado.
Are truly mitigating factors when determining safety of the community and Mr. Baderna's future appearance in court.
No sé que, hasta donde sé, eso no es un atenuante a la hora de analizar el tema de la seguridad de la comunidad y también la probabilidad de que el señor Baderna se presente a su siguiente audiencia.
Certainly, if the opposite were true, that the victim gave a sworn statement and wanted the state to prosecute,
Definitivamente sí. En el caso contrario, si la víctima hubiera deseado proceder con cargos y hubiera dado una declaración,
I don't believe those facts by themselves would
no creo
create,
que eso por sí mismo
would be aggravating factors that should result in a bond increase.
constituyera un agravante que pudiera dar como resultado un aumento de la fianza.
Nothing further, Judge.
Nada más de mi parte, señora juez.
All right, I do find probable cause.
Bien,
At this
considero que
time,
existen indicios probables en este momento.
I'm going to impose a bond of $5,000
Voy a imponer una fianza de $5,000
and no victim contact until further order of
y
the
se le
court.
prohíbe tener contacto con la supuesta víctima hasta que se disponga lo contrario.
All right, good luck, sir.
Buena suerte, señor.
Is there anyone else who needs a Spanish interpreter?
¿Alguien más que necesite interpretación al español?
Hearing no answer, Mr. Rojas, thank you.
Sure.
All right, Shanta Donald,
She's in courtroom 7870, Your Honor.
okay. Yesterday, she was a medical reset. All right. All right, on page 19, I have Anthony Smith. Mr. Smith, you're before the court this morning for one count of grand theft auto. Count 2 is a misdemeanor capias. Counts 3 and 4 are felony capias matters. Those are no bond holds and not for magistrate. You will be before your felony judge tomorrow at 8:30. I do find probable cause, and I will leave the bonds in place as counts 1, $1,000. Count 1, $1,000, count 2, $500, and counts 3 and 4 are no bond holds until you appear before your judge. Okay? Good morning, ma'am.
Good morning.
All right. We'll be in court tomorrow before its division judge.
Okay.
Okay? Kamar Roll. Mr. Roll, you're before the court for 2 misdemeanor capias matters, counts 5 and 6. Count 5 is for a battery, count 6 is for criminal mischief. These are add charges. Does the parties wish to be heard as to bond? Is Mr. Roll being held on bonds?
He's got a $50,000 bond on a carjacking, Judge.
Okay. All right, so as to count 5, the bond is $2,500, count 6 is $1,000. Good luck, sir. Robert McMeans. Mr. McMeans, you're before the court for possession of cannabis 20 grams or less. I do find probable cause. I'll hear from the parties as to bond.
Judge, I had the opportunity to speak with Mr. McMeans. He is 22 years of age. He has lived in Broward County his entire life. Unfortunately, at this time, he's having a difficult time finding work. He does reside with his mother, but his mother is out of town right now. meaning he would not be able to come up with the $100 bond, because he unfortunately has no money at this time in any type of checking or savings account. As a result of the misdemeanor marijuana charge, we're asking the court to ROR him.
State, does Mr. McMeans have any priors?
Possession out of Broward, a possession of cannabis last year. Trespass 2014.
Okay. All right, at this time, I'll grant Mr. McMeans ROR.
Thank you, Judge.
Sir, you need to pay attention to your mail. Make sure you know when you have to come back to court. Good luck. Michael Green. Mr. Green, you're before the court for one count of possession of cannabis 20 grams or less. Does the parties wish to be heard?
Yes, Judge. Again, I had the opportunity to speak with Mr. Green. He is 23 years of age. He's been residing in Broward County 21 out of those 23 years. He does work for a moving company, but at this time the place of business is slow. He has no money in a checking nor savings account at this time. We are going to request the same thing on this, Mr. Green. We're going to ask for an ROR on the possession of cannabis charge.
Any priors on Mr. Green?
He went through drug court on a felony drug charge in 2016. Resisting without violence 2016.
All right, RR, Mr. Green, yeah. Sir, you need to make sure you pay attention to your mail so you know when you have to come back to court. Good luck. Sean Young. Mr. Young, you're before the court for one count of petty theft, count 2 resisting officer without violence, and count 3 is trespassing. I do find probable cause as to those 3 counts. Does anybody wish to be heard as to bond?
Judge, first and foremost, Mr. Young is 33 years of age. He does live here in Broward County. He lives with his grandmother. He's unfortunately not working at this time. I don't know if the state is in a position to make him an offer regarding these 3 misdemeanors, but he's shown interest in resolving these matters here today, if possible.
One moment.
Okay.
Mr. Porter?
Your Honor, this would be, this is Mr. Young's 5th arrest this year. If he wants to resolve all 3 counts, the offer would be adjudication 5 days county jail.
I'm sorry, we missed that?
This is his 5th arrest this year?
Yes, ma'am.
Is that what you said?
Yes.
The offer is adjudication 10 days in the Broward County Jail. And what were the other charges? The other arrests?
February 26th, it was, he was picked up on a capias from a trespass and paraphernalia. Then he was arrested February 4th. That was on a municipal ordinance for paraphernalia and trespass that he resolved. January 17th, another municipal ordinance for paraphernalia and open container. There was also an active capias for another paraphernalia. January 6th, paraphernalia and trespass that he was placed on pretrial release.
Have any of those cases been resolved, or are they all still
It
pending?
appears they've all been resolved.
Okay.
Judge, in explaining the state's offer to Mr. Young at this time, he would like to enter a plea of no contest.
Okay?
Put a 0.
All right, Mr. Young, the sentence will be adjudication in 10 days in the Broward County Jail. Is that what you wish to do this morning? All right, you have to turn your microphone on. Okay, what was your response?
Yes.
Okay, sir, please raise your right hand. Is swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Mr. Young, do you understand the proceedings that you're in today?
Yes.
Is anyone forcing you to resolve your case today?
No.
Do you need more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
And do you understand that you have a right to go to trial? By taking a plea today, you're giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Young?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given. Your sentence, sir, will be adjudication and 10 days in the Broward County Jail. Good luck, sir.
Okay.
Sean Eggert.
Yes, ma'am.
I'm sorry? For what? The sentence? Sorry, Mr. Eggert, you're before the court for one count of resisting officer without violence. And I do find probable cause. And Mr. Eggert's bond, there's a convenience bond of $100. Does the parties wish to be heard otherwise?
Judge, at this time, I spoke to Mr. Eggert. He indicated that he believes the bond has already been posted.
Okay.
It's not ROR.
If not, he was going to request an ROR on this charge, Judge.
I'm sorry? Okay. All right, I've been told that it's not showing that the bond has been posted as yet, but I'm gonna leave the bond in place at $100.
You for that?
All right?
Can't you make ROR?
Judge, would the court consider an ROR on Mr. Eggert, please?
No, I'm denying that at this time.
Okay.
Pedro Torres Rosales. All right. Kevin Wesley. All right, Mr. Wesley, you're before the court for a traffic KPS. It's from 2013. What does Mr. Wesley wish to do?
Judge, I had the opportunity to speak with Mr. Wesley. He is 44 years of age. Unfortunately, him and his wife and his son, who all reside together, had some hard times financially. They were living hotel to hotel. They just recently, about 3 weeks ago, moved into a house because he obtained a job in a warehouse. Due to the fact that this case is a traffic offense and it stems from 2013, I'd ask the court to ROR him on this charge, please.
All right, Mr. Wesley, I will ROR you on this.
And Your Honor, I just want to advise, I just want to advise Mr. Wesley, either way, whatever he wants is fine with me. The offer, if he wants, is, if he's interested, would be a withhold. If he's not interested in coming back to court.
Okay.
Judge, we'd like to thank the state for that offer. He'd like to take advantage of that offer, please, and enter a plea of no contest.
All right, Mr. Wesley, please raise your right hand. Do you swear or affirm to tell the truth?
I do.
All right, sir, you can put your hand down. Mr. Wesley, do you understand everything that's going on here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that by taking a plea today, you're giving up your right to trial?
Yes, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, what plea do you wish to enter, Mr. Wesley?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given. Your sentence is a withhold adjudication and court costs, and I'll give you 6 months to pay the court costs, sir. Good luck.
Thank you, Your Honor.
Yep. Eric Abraham. Mr. Abraham, you're before the court for a traffic capias matter.
You posted the bond?
I'm trying to paper.
All right, this was February 26, 2019, that the capias was issued. I do find probable cause. What does Mr. Abraham wish to do?
Judge, at this time, Mr. Abraham indicated he filled out the form to post bond. However, if BSO does not see that the bond has been posted, I'd ask for a court order allowing him access to his belongings, because he does have money on him in order to post that bond.
Okay.
Corey, does he have any interest in a withhold? That would be the state's offer.
Yes. Yes.
Yes, please.
That's the offer, Your Honor. Withhold court costs.
All right. Mr. Abraham, okay, to answer the one question, the bond wasn't posted, and then two, do you wish to resolve your case today?
Yes, ma'am.
All right, please raise your right hand. You swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. And Mr. Abraham, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Do you need more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
You understand you have a right to go to trial. By taking a plea today, you're giving up that right?
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am. I understand.
All right, what plea do you wish to enter, Mr. Abraham?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence is a withhold adjudication and court costs. I'll give you 6 months to pay your court costs, sir. Good luck.
Thank you.
Brian Penn. Brian Penn. Mr. Penn's bond's been posted.
Bonded.
Thank you.
Daniel Slight bonded also.
All right, thank you very much.
Thank you very much. Definitely.
All right, so Daniel Slack's bond's been posted. So Brian K. Mr. K, you're before the court this morning for one count of DUI, and count two, which is not for magistrate, is a traffic infraction. I do find probable cause, and I'll hear from your attorney.
Thank you, Judge. After speaking with Mr. K, he has been living in Broward approximately 8 to 9 years. He does have a job. He works for the Economy Fire Protection. Unfortunately, at this time, he is living with a friend on the couch. but is able to use that address for purposes of pretrial. Unfortunately, he has no money to post a monetary bond at this time. We were going to ask for standard pretrial release in this matter.
I don't have a problem with that.
All right, okay, so, Mr. K, I am going to release you to standard pretrial supervision. Your attorney will hand you the form that shows you where to go, the address, and the location. You need to make sure that you show up within 24 hours of your release. Failure to do so will lead to your arrest. How about Scott Allen?
North Broward, Your Honor, medical reset.
Judge, it's yeah.
All right, thank you.
You're welcome.
Gregory Gathers? Mr. Gathers, you're before the court today for count 1, grand theft auto. Count 2, possession of methamphetamine. Count 3, possession of MDMA. Count 4, possession of heroin. Count 5, possession of cocaine. Count 6, possession of alprazolam. Count 7, possession of drug paraphernalia. Count 8 is possession of a false driver's license. And count 9 is possession of a counterfeit payment instrument. I do find probable cause as to all those counts. And I will hear from your attorney as to bond.
Thank you, Judge. Just one moment, please. Thank you, Judge, for giving us a moment here. In speaking with Mr. Gathers, he has been residing in Broward County 10 years. He does work. He's self-employed. He's a contractor at this time. When I asked what type of financial bond he could post, he indicated $500 at the maximum. So if possible, on counts 7, 8, and 9, we would ask for an ROR. Counts 1 through 5, we'd ask that the bonds remain the same. And count 6, we'd also ask for an ROR.
That's it. I know. Your Honor, the state would be opposing any RORs. Mr. Gathers is out on bond right now on filed charges of possession of methamphetamine, misdemeanor possession of cannabis, and possession of drug paraphernalia. In addition to that, he has a warrant out of the state of South Carolina from 2013 on a probation violation. Showing previous arrests for failures to appear in Broward and previous arrest out of South Carolina for failing to appear in court.
Judge, Mr. Gathers did acknowledge that he did indicate his failures to appear in Carolina was because they were being sent to the wrong address. He also wanted the court to be aware that the warrant out of South Carolina is a non-extraditable warrant, according to Mr. Gathers. He's indicated he has come into contact with law enforcement before, knowing that warrant has been active. And South Carolina, according to Mr. Gathers, does not want to extradite him on those matters.
All right, I do find probable cause,
I understand.
Mr. Gathers, has a pending drug charge, and now he's got 5 new, drug charges in addition to the other charges that are presented here today. I do finding probable cause as to count 1, I'm going to impose a bond of $2,500. And then all the other counts, the bonds will remain, in place. Good luck, sir. Devon Madden. Mr. Madden, you're before the court for 1 count of robbery by sudden snatching without a firearm. Count 2 is stalking. And count 3 is grand theft. I do find probable cause as to all 3 counts.
And, Your Honor, the state would be requesting a $5,000 bond on count 1, a $2,500 bond on count 2, asking that the $1,000 bond on 3 be left in place. Order no victim contact with Letitia Tinker. And based on the nature of the stalking allegations, I would also be requesting pretrial release with a GPS monitor to ensure that the court's no contact order is complied with.
Judge, the defense does not really have much of an objection to the state's request, just a minor one. Mr. Madden has been residing in Broward County 18 years. He does work in the hospice industry. Unfortunately, he doesn't have any money saved in an account at this time. He indicated $500 would be the maximum he'd be able to post. As a result, we'd have no objection to pretrial release, but we're asking that count 1 be a $2,000 bond and count 2 be a $2,000 bond.
All right, I find probable cause, and I'm also noting that the court has great concerns for the community based on the allegations that have been presented
Judge, I'm sorry,
here.
you're going in and out at this time.
All right. I find probable cause, and I also have concerns for the community based on the allegations that has been presented in this affidavit. And so I find that a reasonable bond at this time, reasonable release conditions is $5,000 on count 1, $2,500 on count 2, $1,000 on 3, and no victim contact as well. I'm gonna add a GPS.
$750 to get out, if not.
Elroy Bulgin.
He bonded, Judge.
Okay, thank you. David Tharp.
Yes, ma'am.
Mr. Tharp, you're before the court for 3 counts of grand theft. Count 4 is resisting officer without violence. Counts 5 and 6 are misdemeanor capious matters.
Judge, is the state willing to make an offer on counts 5 and 6 at this time?
Your Honor, 1, the criminal mischief is going to have restitution, and also, was he
He's
on?
on pretrial release on counts 5 and the last 2, the
And
ones
I
that have the no bond hold.
And I suspect that might be why Judge Solomon made them no bond.
All right, I'm not inclined to resolve the case before the 5 and 6.
Thank you for that. Mr. Tharp did want the court to be aware on counts 5 and 6. The allegations are against his friend, and according to Mr. Tharp, the alleged victim sent a letter to the state asking for prosecution to be declined.
And I have one too.
With that said, on counts 1, 2, 3, and 4, we're okay with bond set on count 4. We are going to ask that on counts 1, 2, and 3, the court reduce the bond to $500 on each count. At the same time, Mr. Tharp is asking for help for a substance abuse problem. He is asking that the court order him into the SAP program, and then he'd be able to financially post those bonds once completion of the SAP program.
Your Honor, one thing I think the court should be aware of, I looked into the misdemeanor matter a little bit. I believe the reason why Judge Solomon put the bonds at no bond is the hearing he failed to appear at was the state's motion to revoke bond. The allegation in the motion is that Mr. Tharp violated a condition of pretrial release, that being the no contact order or no return to the residence, when he allegedly went to the victim's residence, walked through a open door, physically touched and verbally threatened the victim. He then, that was on February 28th. Then there's an allegation that on March 1st of this year, he returned to the same residence again and placed his hand on the victim's throat and verbally threatened him. There's allegations that on 2 more occasions, he went to the same victim's residence.
Okay.
Judge, I just so you know, Mr. Tharp wants to speak. I have given him legal advice not to speak about the facts of his case, but he's now going to speak to the court, please.
Okay.
Yes, Your Honor. I just want to say this to you, Your Honor. I've been here since '61. I've been locked up 27 out of 30 years. This guy here is the only friend I have. I've been living with him a year. I've lived with him a year, Your Honor. He is a good friend of mine. He's already called, the DA's already called him. He's done dropped the assault. He does not want no trouble with me. He's on opiates real bad because that's what they give him. He drinks a lot and he forgets his memory. I'm his caretaker. I pick him up off the ground every day, and this is not what's happened. The people have, he don't remember what he says, and there's no way in the world that I would touch this guy. I take
All right,
care of him.
Mr.
I give him his
Tharp,
food and everything.
I think you should take your attorney's advice and not talk about the case. Go ahead.
Could I do something? Could I do something with the resisting arrest, ma'am,
No.
today, so I can go to court?
No, sir, I'm not going to resolve any matters here today. Yes, ma'am.
Your Honor, Mr. Clark is currently on pretrial supervision in case number 190000138 MM10A. At this time, we're requesting a revocation of his supervision.
All right. All right, Mr. Tharp, you're on pretrial supervision on case number 1900138 MM10A. Are those but those are the charges that are already capias issued. So there's no, so I won't take any action. There is no point in me putting another no bond hold on the same case. All right. So I am going to, the allegations here, sir, I don't know anything about the other cases. You have to go before your judge. I know nothing about an affidavit not to prosecute, so I can't take that into consideration. The allegations that we have here are on 3 consecutive days. You're doing the exact same thing, going into Publix and taking steaks. Those are the allegations. So I find probable cause, and I am going to leave those bonds in place, counts 1, 2, and 3, 1,000, 1,000, 1,000, and 100 on count 4. And as I said before, there are no bond holds on the misdemeanor 5 and 6, and you'll be before your division judge tomorrow at 9 a.m. Good luck, sir.
So you won't give me nothing on the
No,
the bond?
sir. No, sir.
The bond is, you crackers get shot the fuck down.
All right. On page 22, I have Julio Naranjo. Sir, you're before the court today for one count of aggravated assault with a deadly weapon without intent to kill. And I do find probable cause as to that charge.
Judge, unfortunately, at this time, I'm unable to communicate with the individual. He does speak Spanish.
I have
It
some
would help.
information, Mr. Hill.
Right, but he needs to understand what's going on, and
he
I did
obviously
ask
needs to
before if someone else
Right.
needed a Spanish interpreter.
He understands English. I just can't really understand. But he can hear you.
Right, but we all need to be on the same page. So can you please call for the Spanish interpreter?
We're gonna get the
who was-
Spanish interpreter.
Who was already
Okay.
here before.
We're gonna get somebody to speak Spanish here in a couple minutes, okay? Just have a seat.
Alfred Turner,
Yes.
Mr. Turner, you're before the court. Counts 1 and 2 are felony violation of pretrial, and count 3 is a misdemeanor capias. Counts 1 and 2 are not for magistrate. Your bond on count 3 is $500, and you have court dates March 27th and March 28th on your cases. Good luck, sir.
Judge, just one thing on Mr. Turner, please.
Yes.
Unfortunately, at this time, he's in some pain at this time.
Yes.
Can I get a court order for him to seek medical treatment? He's having major problems with the discs in his neck.
Definitely.
Thank you.
And the judge did an order to release him on pretrial on those. So,
We bring him back,
Mr.
Mr.
Hill?
Turner?
Can you bring Mr. Turner back, please?
Mr. Turner?
Well, this doesn't indicate that he was ROR'd. When did that, what did you say? He was released to what?
18, Autumn.
He's on pretrial Elmo on counts 1 and 2?
So, Mr. Hill, the situation is, the only thing that's holding him in custody, they're telling us, is count 3.
I just want to be, hold on, Mr. Goldberg. I just want to be sure that that's what's being said. Even though 1 and 2 is not for magistrate. Yes. But they put him back on pretrial with level 2. Okay. And then he brought him back to magistrate because he was never magistrated on the. All right, so then I'll ROR him on count 3 and whatever the status is on the other 2, he's on Elmo. Right, on counts 1 and 2, I'm being advised by confinement status that he's placed on Elmo on those 2. And so I've ROR'd him on count 3. All right, Johnny Knights.
He is in North Broward.
Mr. Knights, you're before the court today. Count 1 is possession of drug paraphernalia. Count 2 is violation of pretrial. And that's a no bond hold, not for magistrate. And so your bond on count 1 is $100. I do find probable cause. And you will be before your division judge 327 at 8:30. Good luck, sir.
Thank you.
Marcus Calloway. Mr. Calloway, you're before the court this morning. Count 1 is burglary with assault or battery. Count 2 is prevent or hinder firefighter or equipment. Count 3 is burglary of an unoccupied conveyance unarmed. And count 4 is petty theft. I find probable cause as to all the counts.
Judge, we would be objecting to PC on count 1. I read the probable cause affidavit. I see the allegation of a burglary going into the school, but I don't see an assault or battery attached to the burglary.
And Your Honor, this
Mr.
isn't a
Burke.
PC issue. I direct the court's attention. You can see a different statute number was entered in the data entry for the booking process. The officer just charged him with burglary of a structure.
Discussed.
Yeah. So it's a burglary,
Michelle.
burglary for structure.
Yes.
This happened before January?
He was, no, what do you mean January? He was arrested
he
in
was-
February.
Okay.
All right, as to bond?
Your Honor, on the two burglaries, I'm gonna be, on the burglary going into Boyd Anderson, I'm gonna be requesting a $5,000 bond. On the burglary conveyance, on count 3, a $2,500 bond. I would also advise the court, Mr. Callaway these incidents occurred on February 13th. He was arrested on February 12th. He was arrested on February 13th for possession of burglary tools and burglary of a conveyance. Your Honor, ROR in the pretrial release. Obviously, these don't violate his release conditions. They occurred previous to him being placed on pretrial. I just want the court to be aware because it's becoming a bigger issue now, a bigger picture of a similar type of activity than just that one incident.
Judge, based upon the state's information, we then would be requesting pretrial release on the new offenses. This young man is 18 years of age. He's been living in Broward County since the age of 2. He has been looking for work. He actually had an interview with Burger King yesterday, but obviously was unable to make that. According to Mr. Callaway, his history is one prior juvenile diversion case that was ultimately dismissed. As a result of his lack of history and the innocent till proven guilty, we are going to ask that the court place him on pretrial on counts 1, 2, 3, and 4. And in the alternative, if the court was not inclined to do so, Mr. Callaway's indicated he could post a $200 bond at most. We'd ask for a $1,000 bond on count 1, $1,000 bond on count 2, and ROR on counts 3 and 4.
All right. I do find probable cause, as I said before. Everyone who comes before this court is innocent until proven guilty. What I need to look at is the safety of for the community. I need to take that into consideration. The allegations here that Mr. Callaway went into the high school, they took out all the fire extinguishers and let everything out. After going through several spots before getting into the location to take those fire extinguishers. So I have concern for the safety of the community. I have to take that into consideration. There's also, it's the other allegation of going into a Carriage Homes gated community and also committing the same type of crime. So I find that a reasonable bond on these counts, as I said, I found probable cause for burglary for structure on count 1. It is going to be $5,000. Count 2 is $2,500. Count 3 is $2,500. And no bond is required on count 4. Good luck, sir. Kenyatta
Judge.
Selassie.
He's approaching.
Judge, I do have a PC objection as to count 3.
Okay.
My objection is that contact is made with him. He is arrested, search incident to arrest, comes up with several baggies of what is tested positive for methamphetamine. And so he's, you're actually in the right place. he gave a false identification to a law enforcement officer. That's the appropriate charge, count 1. Count 2, possession with intent, methamphetamine. I don't see count 3 at all, possession with intent, MDMA. So I would object to PC on count 3 alone. And I'm assuming that this is our Vietnamese trial. Thank you.
Yeah, I'm fine with just a straight possession charge, Your Honor, on, let's see. Yeah, I'm just trying to figure out. This whole thing got a little screwed up. Because it looks like the officer's intent was 1 count of possession of methamphetamine, 1 count of possession of methamphetamine with intent, and somehow that turned into 1 count of possession of methamphetamine with intent, and 1 count of possession of MDMA with intent. So, Your Honor, I would ask the court to find PC on count 2 for simple possession of the methamphetamine, and then just no PC on count 3, which obviously I will not be asking for any time.
All right. So, Mr. Salasi, you're before the court for 1 count. Count 1 is false ID given to a law enforcement officer. Count 2 is possession with intent to sell, deliver, and manufacture methamphetamines. Count 3 is possession with intent to sell or manufacture or deliver MDMA. And count 4 is a municipal ordinance. I find probable cause as to counts 1, 2, and 4. No probable cause for count 3. All right, and then I'll hear from the parties as to bond.
Thank you, Judge. Kanata is 20 years of age. The problem with Kanata here, Judge, is he's not a Florida resident. He was down here visiting friends for spring break, and this allegation occurred. His mother resides in Pennsylvania. His sister resides in Georgia. His mother is on a fixed income. He was down here staying at an Airbnb. He's never been arrested before, according to Kanata. But unfortunately, financially, he doesn't believe he'd be able to come up with much money. We are asking the court at this time to impose a $1,000 bond on count 2. Unfortunately, pretrial is not going to work without an address. I'm assuming we can't do pretrial at an Airbnb. So I don't know how else to help Mr. Kanata at this time, other than trying to keep the financial bond kept as low as possible.
Your Honor, I don't have an objection to a $1,000 bond on 2 and ROR on the remaining counts.
Okay. All right, Mr. Salasi, as to count 1, your bond is $100. On count 2, it's $1,000, and counts 3 and 4, you'll be ROR'd.
Your Honor?
Yes.
I've just asked if the court could advise Mr. Salasi just what he needs to do for a future court date since he does not reside in the state.
Well, sir, you need to, well, what address did you need to give an address, a mailing address to the clerk's office so that they have that information. It has to be an address where you will receive, you will know and receive the mail when it comes in. Because if you don't appear for court, there is going to be a warrant issued for your arrest. So you need to make sure that that's clear. The booking report and the affidavit has your address as at large, so you need to make sure that that's cleared up. Okay?
Judge, in speaking to Kanata, and I'll explain that to him in full detail, Judge, on how to go about doing that. But he is very concerned, even about the $1,000 bond. Did the court consider, based upon his lack of history, RORing him on count 2 as well? He doesn't even believe, he's down here with friends, and we all remember being in college, 20 years old, college students. We don't have money. He doesn't believe his friends would be able to financially post that bond for him.
Oh, I don't remember being in college. Listen, we have to take the allegations here seriously, and I'm gonna leave the bond on count 2 at $1,000. Okay?
Thank you.
All right. Dwight Porter. Oh, wait a minute. We have the, wait a minute, Mr. Hill, we have the Vietnamese interpreter.
This was Miss Nguyen all the way back on page 2.
And so let's go back to. All right, good morning, ma'am.
Good morning, Your Honor.
Can you please raise your right hand? Do you swear or affirm to, what language are you translating from?
Vietnamese.
From Vietnamese to English and English to Vietnamese?
Yes, I do.
Okay, what's your name?
Vivian Twang.
All right. Ms. Nguyen, you're before the court today
Anh trước mặt là tòa án ban nha.
for count 1, touch or strike battery,
Anh đánh
and count 2 is domestic battery by strangulation.
rồi cái tội thứ hai là cái chuyện trong gia đình mà cũng đánh đập nhau đó.
All right. I do find probable cause as to both counts.
Bà tìm ra được tất cả những chứng nhận.
Judge, it was relayed to me that Miss Nguyen had hired a private attorney. I'm just asking if the court could inquire of Miss Nguyen.
What was the question, Mr. Goldberg?
Sure, it was relayed to me. I can't recall how, but that she had hired a private attorney. She. So
It's a female.
It look like a man.
It's female.
Okay. Anh có thuê luật sư riêng không?
Em chuẩn bị gọi chị ơi.
He's going to call the lawyer.
So she has not hired one as yet.
Hiện tại bây giờ không có luật sư phải không?
Dạ không có.
Right now I don't have.
Okay. All right. So I need to set her bond. So I need to hear if she can tell me how much bond she can afford, or if she has someone who can post her bond.
Hôm nay bà chánh án á, muốn có anh post cái bond đó, chị post cái bond đó mà bây giờ họ để coi thử chị có bao nhiêu tiền để bond ra.
1.000 hoặc là 2.000 có được không?
Hả?
1.000 hoặc 2.000.
1,000 or 2,000.
Okay. All right. I'll hear from the state attorney now.
Your Honor, just based on the allegations,
Ông dựa trên cái câu chuyện mà anh bị phạt hả?
I'll be requesting a $1,000 bond on one.
Và ông muốn làm một cái 1.000 đồng kêu cho cái tội thứ nhất.
A $4,000 bond on two.
4.000 cho cái tội thứ hai.
An order of no victim contact.
Và không có đến gặp cái người nạn nhân.
Yes.
Yes.
Okay.
I would ask, just to clarify, if we can do 1,000 on count 2. I believe Miss Nguyen just testified she can afford $2,000.
Ông luật sư bên này ông cãi nói là hồi nãy chị nói là chị chỉ có 1.000 thôi đó, thì ông nói là chứ làm cái bond 1.000 đồng.
Dạ vậy như vậy cũng được chị ơi.
That's okay.
She also said 4,000 was okay as well.
Chị nói 4.000 được luôn hả?
Tại vì nếu mà giảm chút cho em xuống có được nữa không?
No, if you can lower, that's good for me.
Please.
Please.
All right. So the court finds probable cause as to count 1.
Mà tội thứ nhất của anh,
I'm imposing a bond of $1,000.
Bà để cho anh 1.000 đồng tiền bond.
And on count 2.
Và tội thứ hai,
I'm imposing a bond of $2,000.
Tội thứ hai là 2.000 đồng bond.
And she has to have no contact with the victim in this case.
Và chị không có được tới gặp cái người nạn nhân trong cái case này nha.
Until further order of the court.
Cho tới chừng nào có cái luật khác của như phiên xử tới á. Ok, từ đây đó không có nói chuyện với người nạn nhân.
No contact means no phone calls.
No contact nghĩa là anh không được gọi điện thoại.
No letters or
không
text.
Gửi thơ, không có text.
No text messaging.
Không có được text message.
And no asking a third person to get in to speak on her to her.
Và anh không, và chị cũng không có nhờ người khác mà để nhắn tin.
Okay, do you understand that, ma'am?
Anh hiểu, chị hiểu tất cả những cái này không?
All right.
Yes.
Good luck. Good luck.
Thank you.
Thank you.
Bye-bye.
Thank you. Oh, okay. All right. All right. Thank you. Dwight Porter. Mr. Porter, you're before the court for one count of possession with intent to sell, deliver cannabis within 1,000 feet of a park. I do find probable cause. I'll hear from the parties.
Thank you, Judge. Mr. Porter is 48 years of age. He has resided here in Broward County his entire life. Unfortunately, at this time, he's not working and doesn't have any money in a checking or savings account. He lives with his mother in Dania Beach. Would the court consider, I understand it's a serious felony, but it's a felony only because of the distance of where he was located. Otherwise, it would be a misdemeanor charge. Would the court consider an ROR in this matter? And if not, then Mr. Porter is asking for a standard pretrial release. I take that back. I apologize. It's not a misdemeanor. I see it's possession with intent. I apologize.
And Your Honor, I would just note, to say, well, if it wasn't in the park, but that's the whole point, and that's the whole reason why the legislature created an enhancement. The state has a concern about people selling drugs in our parks in the middle of the day when there could be other people and possibly children present. I would note, based on the amount that was found and how it was packaged, the evidence would appear to be very strong that Mr. Porter was actively involved in drug dealing. Now, he does have drug priors. I would note they are dated. And because of that, Your Honor, I would not have an objection to the court reducing the bond, but I do believe some bond would be appropriate on this second-degree felony.
All right. I do find probable cause. I am going to impose a bond of $1,500, but that's also going to be with a level 2 GPS to pretrial supervision. Yes, ma'am. All right, good luck, sir. Devon Davis. Devon Davis. Mr. Davis is before the court for one count of grand theft auto, and count 2 is possession of weapon or ammo by a convicted felon. I do find probable cause. As to bond.
One moment, Judge.
Sorry, Judge. Again, I had the opportunity to speak with Mr. Davis. He is 25 years of age. He moved here to Broward about a week ago, but he lived in West Palm Beach County his entire life. He was working for CPM Landscaping, or still does work for CPM Landscaping. He could live with his grandmother, who is in West Palm Beach County. She does have a valid address. He is allowed to live there. We would ask, unfortunately, he can't post a monetary bond at all. I asked him even if $100 he'd be able to do. He indicated no. So as a result, we're going to ask for pretrial release. and allow him to live in Palm Beach County with his grandmother.
Your Honor, I'm going to be requesting a $3,500 bond on count 2. As you can see in the probable cause affidavit, he has multiple prior felony convictions. In 2014 and 2013 in Palm Beach County, he was convicted of 2 burglary structures, a burglary of a dwelling, and grand theft. He was sentenced to 3 years in Florida State
I
Prison.
don't talk about priors at these type of hearings.
Nothing further, Judge.
Judge, Mr. Davis indicated to me, and forgive me for not having the probable cause affidavit in front of me at this time, but he indicated, without getting into the facts of the case, do you see a constructive possession and not an actual possession of a firearm in the PC?
That's correct.
Therefore, if that's the case, I'd object to probable cause being found on count 2.
Right, I still find probable cause. The allegations are that Mr. Davis is the person who was sitting in the front passenger seat of the vehicle, and then the silver firearm was retrieved from directly under the front passenger seat. So I do find probable cause as to both counts. I will impose a bond on count 1 as to $1,000. And count 2, I'll impose a bond of $2,000. All right, good luck, sir. Francisco Figueroa. Mr. Figueroa, you're before the court. Count 1 is possession of THC. Count 2 is operating without a valid driver's license. And count 3 is obstruction. It's a traffic infraction. I do find probable cause, and I'll hear from the parties as to bond.
Thank you, Judge. Mr. Figueroa is 23 years of age. Unfortunately, at this time, he's not working. We are going to ask for an ROR. As the court is aware, this is simply marijuana, but because it's the oil form, for some reason our legislators thought that that should enhance a crime when it's actually the same exact thing. It's THC, whether it's in an oil form or in a flower form. I understand the law is what it is, but in reality, it's still the same ingredient. As a result of that, we are going to ask that the court ROR him on the possession of THC.
State?
Thank you. Your Honor, whatever the court believes
Does
appropriate.
Mr. Figueroa have any priors?
He had a trespass in 2016, a theft in 2013. Whatever, however you believe is appropriate.
Okay.
Proceed, Your Honor. I'm fine with that.
All right. All right, I will ROR Mr. Figueroa on count 1. Counts 2 and 3 does not require a bond. Sean O'Connell. Mr. O'Connell, you're before the court for 1 count of possession of fentanyl. Count 2 is possession of drug paraphernalia, and count 3 is a municipal ordinance. I do find probable cause as to all 3 counts. Does the parties wish to be heard?
Judge, I had the opportunity this morning to speak with Mr. O'Connell. The problem with Mr. O'Connell is at this time he is homeless, and does not have any access to any type of money. He is not objecting to any type of help or drug treatment. Would the court consider having Mr. O'Connell screened by Bark? And if so, if he qualifies, then we could do a custody-to-custody transfer to allow him to get treatment?
I have no objection to that.
Your Honor, the only thing I would ask is if the court's inclined to do that, that it be in conjunction with pretrial, so that if he doesn't comply with Bark, if he, there's something in place, a mechanism in place, that it could be, his assigned judge can be advised and it can be dealt with. What? For where?
For, oh.
He has evidently he has a pending drug case in the state of Pennsylvania. A warrant was issued back on September 28, 2018. However,
All right. I will sign the order for the custody to custody for Bark, but he's also going to be on pretrial supervision.
Okay, Judge, thank you.
Okay. And well, he's gonna be evaluated by Bark, so.
So are you doing a Bark evaluation first to see if they're gonna take them, or because if he takes the custody of Bark will take them?
But it's not with the bond. I'm not doing he's gonna be ROR'd once.
Certainly, Your Honor. I imagine the public defender is going to be a point in this case. If there's a situation, and I don't mean to speak for Mr. Goldberg, but he's very thorough in keeping track of their clients. And if there's a situation where he's being held, I imagine the public defender would file the appropriate motion in front of the assigned judge to have that matter addressed.
So, Judge, I just want to make, you know what, I'll speak with her and make sure I get wording on that order correct.
So we know it's pretrial supervision. He's gonna do a Bark evaluation. If he's accepted by Bark, it's gonna be custody to custody. All right. Mark Marat. Sir, you're before the court for one count of grand theft auto. Count 2 is possession of cocaine. Count 3 is a parole violation. That's a no bond hold. I do find probable cause. Your bond, sir, on counts 1 and 2 are $1,000. There's a no bond hold on your parole violation, and you will be able to go before your parole board to resolve that issue. Good luck, sir.
Judge, we wanted to advise that his parole is interstate. So the state that he's
Okay. Walton Lalimond. Sir, you're before the court this morning. Count 1 is burglary of an unoccupied dwelling unarmed. Count 2 is petty theft. Count 3 is driving while license suspended. And count 4 is resisting officer without violence.
Judge, I don't have a probable cause objection. I just want to note, this is the co-defendant of, I think her name was Miss Tilly. I'm sorry, Miss Twitty on page 8. Judge, the co-defendant allegedly attempted to remove, or did remove a package from the front porch. It doesn't appear there's any allegations that he attempted to actually enter the structure of the dwelling. It is properly before the court as a burg dwelling, as it is an attached porch, but it is not a traditional burglary as we come to understand. And I would just, it's not a PC objection, but I'd ask that you take that into consideration in setting a bond today.
7171 or 12533?
1253.
Okay.
Your Honor, Mr. Lalamid is currently on pretrial supervision in case number 180125553 CF10A, possession of cathinones and resisting without violence. At this time, we're requesting a revocation of his supervision.
Joe? He was placed on center pretrial on 7171 as well.
Okay.
On the agreement here dated February 22nd.
Okay, Mr. Lalamond is on pretrial supervision on case number 18-012553 CF10A. Pretrial is, pretrial is asking, pretrial is asking, pretrial is asking that, your pretrial supervision be revoked.
I'm sorry, Judge, could you repeat the case number?
18-012553 CF10A.
187171 CF10A, same charges.
Same, which charges?
Okay.
Possession of substituted cathinones and resisting without violence.
Okay, so he has two separate cases that are the same, okay,
I gotta run it through.
all right. So, based on that, I am going to, do we also have that other one? While you're doing that, did you say the case number is 17-7171 CF?
187171 CF10A.
Okay. All right. So, Mr. Lalamond, I know you were saying to your attorney that you don't understand, but you have been placed on pretrial supervision on two prior cases. Case number 18-012553 CF10A. The charge there is possession of cathinones, and count two is resisting without violence.
Yeah, I understand that.
There is also, you're on pretrial supervision on another matter, case number 18-717 CF10A, for the same charges, possession of substance cathinones and resisting without violence. And now, today you're before the court for an allegation of a new arrest on March 21st. So with that, I am going to grant pretrial supervision's motion to revoke your pretrial supervision. And I am going to impose a bond on count one, $1,000. Count two, $500.
Once a judge fixes this for you,
I'm doing the same thing
get out.
on the second case, count one, $1,000. Count two, $500. Both of them is the same Yes, 7171. Is it? Yes. Yes. No, just on the two, it's two.
Thank you.
So on the new arrest, I am going to impose $1,000 bond on that as well. And I believe with this co-defendant, I said no return to that location. So I'm gonna impose that as well.
Thank you, Judge.
Thank you.
All right. Clement Alexis,
Bonded.
all right. Zane Kearns,
Bonded.
okay. John Maselli. John Maselli? Mr. Maselli, you're before the court for count 1, possession of heroin, and count 2 is a traffic infraction for speeding.
Yes, ma'am.
I do find probable cause, and I'll hear from your attorney as to bond.
Thank you, Judge. Mr. Maselli's 39 years of age. He's lived in Broward County his entire life. His work is sporadic. His father's a CPA, and during tax season, he helps his father in the office during that time. Unfortunately, he doesn't have any money to post a financial bond. So as a result, would the court be willing to do pretrial release on this matter?
Does Mr. Maselli have any priors?
One moment, Your Honor. Yes, Your Honor, he does. He's been in the state prison for child neglect and battery on a law enforcement officer. I would also note, he is the registered owner of the 2014 BMW he was driving at the time of his arrest.
All right, Mr. Maselli, your bond on count 1 is $1,000. Good luck, sir.
Thank you.
Jorge Rodriguez. Mr. Rodriguez, you are before the court for 1 count of driving while license suspended, 3rd or subsequent offense. I do find probable cause. Does the parties wish to be heard as to bond?
Just one moment, Judge, please.
Okay.
Judge, if the court is inclined in speaking with Mr. Rodriguez, would the court be willing to reduce the bond to $500 instead of $750?
All right. Let me hear from the state.
I'm just pulling his driving record quickly, Your Honor. The request was for a $100 bond, Your Honor?
500.
500? Oh, fine with 500.
He has no priors, or is it just except for driving?
I think, let me check, let me make sure.
Yes, don't go anywhere.
For the most part, driving, Your Honor.
All right. Okay, Mr. Rodriguez, your bond is $500, sir. Good luck. All right, let's recall Mr. Naranjo.
Sheila. On the next case,
Julio.
Gonzalez.
Judge, at this time, he declined the services of the public defender.
John Gonzalez.
All right, the Spanish interpreter is here, so,
Originally set at.
Mr. Ma'am, were you here on this case as well? Does he have a private attorney?
1,000. Thank you.
Okay.
Señor Naranjo ha contratado un abogado particular.
No sé si mi esposo lo habrá hecho.
I don't know if perhaps my wife has.
Judge, his wife is in the courtroom, and they do not have a private attorney. Is that correct?
Su esposa está aquí en la sala y no han contratado ningún abogado particular.
Well, I know that I just asked her that, so I know that they don't have a private attorney. So my question is, are you planning on hiring a private attorney?
Dice la jueza, dice, yo sé que no tienen abogado particular, entonces mi pregunta es, ¿piensan contratar un abogado particular?
Bueno, si no hay necesidad, no lo hago.
Well, if I don't have to, I won't.
Well, I can't tell you if you have to.
Yo no le puedo decir si usted tiene que hacerlo o no.
I just need to let you know
Solo tengo que hacerle saber
that you are entitled to representation at this stage of the proceedings.
que en esta fase del proceso usted tiene derecho a ser representado.
And I just want you to know
Y debe estar consciente
that if you wish to accept the services of the public defender's office,
de que si usted desea aceptar los servicios de los defensores públicos,
the attorney is there so that you can speak to that
el
person.
defensor público está ahí para que usted pueda hablar con él.
Sí, él me está atendiendo aquí. Si él me quiere ayudar, que me ayude, eso no es problema.
Yeah, he was helping me out here. If he wants to help me out, that's fine. That's no problem.
Well, that's not how it works.
Es que así no es como funciona.
If you wish to use the services,
Si
you
usted
need to
desea-
let them know.
Si usted desea utilizar los servicios de los abogados de oficio, tiene que avisarles.
It's not if they want to help
No
you.
es que si ellos quieren ayudarle a usted.
The question is, do you need the attorney?
La pregunta es, ¿necesita usted el abogado?
Sí.
Yes.
Okay, you are before the
Bien.
court, sir,
Usted está ante este tribunal, señor,
for one count of aggravated
porque
assault
está acusado de un cargo de lesiones agravadas
with a deadly weapon
con arma mortal
without intent to kill.
sin intención de matar.
I do find probable cause on this count,
Considero que existen indicios probables de delito en este cargo
and so now I will hear from the parties
y por tanto ahora voy a escuchar a las partes
in regards to setting your release conditions.
con respecto a las condiciones de su excarcelación.
Judge, if I may go first before Mr. Hill,
Su señoría me permite hablar antes del fiscal.
just to proffer what the wife has said to me, and I'm sorry, ma'am, I don't recall your name.
Solo para externar ante la corte lo que me ha dicho la esposa. No, disculpe, señor, no recuerdo el nombre. Ana.
Anna is before the court here. She told me that she lives with her husband along with the two children that they have in common.
Su señoría Ana me ha dicho que ella vive con su marido junto con los dos hijos que tienen en común.
Also in the home are her mother and father.
También viven la madre y el padre de ella en la misma casa.
She works as a manager of a Pizza Hut,
Ella trabaja como administradora de un local de Pizza Hut
and she's advised me that money is very tight around the house.
y me ha informado que están muy apretados de dinero en la casa.
I believe this incident is between Mr. Naranjo and some strangers. I don't believe the alleged victims are known to him.
Tengo entendido que este incidente ocurrió entre el señor Naranjo y unas personas desconocidas. Creo que no son personas conocidas para la familia.
I think there's more to the story than what we have in the PC, but obviously we only have what's in the PC here.
Y creo que lo que ocurrió incluye otros hechos que no están incluidos en el affidavit sobre indicios probables. Si bien es cierto que solo tenemos ese affidavit como información en este momento.
We would have no objection to a no victim contact and a no return, obviously.
No tendríamos ninguna objeción a que se le impusiera como medida cautelar el que se le prohibiera tener contacto con la víctima y se le prohibiera regresar al sitio, obviamente.
But we'll be asking the court to place him on pretrial release.
Pero sí solicitaríamos que su señoría le conceda la excarcelación bajo medidas cautelares
So he can return home to his family.
para que pueda regresar a casa con su familia.
And I don't know if Mr. Hill has additional material to add, but I just wanted to proffer.
No sé si el señor Hill tendrá algún comentario adicional, pero yo simplemente quería externar eso que me acaba de explicar la esposa del individuo.
The only thing I'd like to add, Judge, is if the court was not inclined to place him on pretrial release, in speaking with Mr. Morjan Naranjo, we would be requesting a $2,000 bond on count one.
Su señoría, lo único que agregaría yo es que si su señoría no estuviera dispuesta a liberarlo bajo medidas cautelares, solicitaríamos que se le impusiera una fianza de $2,000 para el primer cargo.
Okay, state.
Fiscalía.
Your Honor, Mr. Morejan Naranjo has no criminal history.
Su señoría, el señor Morazán Naranjo no tiene antecedentes penales.
That being said, I'm going to be requesting a bond of $3,500 and no victim contact.
Sin embargo, sí voy a solicitar que se le imponga una fianza de $3,500 y que se le prohíba tener contacto con la supuesta víctima,
And no possession of weapons.
así como que se le prohíba tener armas.
According to Officer DeCorto,
Según el oficial de corto,
both the victim and Mr. Morejan Naranjo stated that he struck the victim in the face first.
tanto la víctima como el señor Morazán Naranjo dijeron que el señor Morazán fue quien golpeó a la víctima primero en la cara.
And frankly, just going by the allegations, I'm a little concerned
Y sinceramente, si nos atenemos únicamente a la acusación, estoy un poco preocupado
that Mr. Morejan Naranjo had a readily accessible large kitchen knife
por el hecho de que el señor Morazán Naranjo tenía tan a mano, de tan fácil acceso, un cuchillo grande de cocina
underneath the driver's seat of his vehicle to begin with.
debajo del asiento de conductor de su vehículo.
Okay. I do find probable cause.
Bien, considero que existen indicios probables.
And I will impose a bond of $2,000
Voy a imponer una fianza de $2,000.
no victim contact,
Se le prohíbe tener contacto con la supuesta víctima.
no return to this location,
Se le prohíbe regresar al sitio de los hechos.
no weapons or firearms,
Y se le prohíbe poseer armas o armas de fuego.
Good luck, sir.
Buena suerte, señor.
Thank you.
You're welcome.
Is that all for the Spanish, Your Honor? For now.
Is there anyone else who needs a Spanish interpreter?
¿Alguien más necesita intérprete?
Not at the main jail, no.
And anywhere else? Thank you. Thank you. John Santos Gonzalez. Mr. Gonzalez, you're before the court. It's a change of charge from resisting officer with violence to battery on an officer. What was the bond?
It was originally set at $1,000, Your Honor. I'd just be requesting that the court keep the $1,000 bond in place.
All right. So Mr. Gonzalez, just so you understand, it's just the nature of the charge that's been changed. And so the bond was $1,000. I'm going to leave that in place, okay?
Judge, Mr. Gonzalez, would the court consider, he's been in custody 40 days already. He's 32 years of age. He's lived here his entire life. He works in the construction field. Unfortunately, the $1,000 bond, he's not even able to post a $100 bond. He indicated the last time he was in trouble was 2012. He did have a DV case last year that was no pros, but prior to that, according to Mr. Gonzalez, it's been since 2012. He does reside with his grandfather as well. We would be asking if the court would consider standard pretrial, because he indicated if he had a monitor on him, he works with concrete all day long, and that could cause a problem with his work, having the monitor on dealing with concrete and wet cement. So we would be asking for standard pretrial release.
This is count 3. What are the bonds on? Is he in custody on something
It
else?
originated as a domestic violence case, Your Honor, with charges of aggravated battery against a victim over the age of 65.
Okay.
And battery. Ultimately, those 2 counts were dropped. I would note, the listed victim of the aggravated battery and a victim over 65 is his grandfather that Mr. Hill referenced earlier.
Okay. So those 2 counts were dropped.
Yes.
All right. And is there another reason why he's been in custody? The indication is that he's been here for more than 40 days or something.
One moment.
Okay, there were just no info. All right.
Which was in the 33-day period when we filed the case. Why he just had to change the charge process now, I don't know.
So this charge has already been filed?
Yes.
Okay. I have no case number. Okay.
He's also scheduled for arraignment before Judge McCarthy Thursday morning.
All right. All right, so I will place Mr. Gonzalez on standard pretrial supervision. And you have to, I'm being told that you have court on Thursday, so. All right?
Thank you, Judge.
Thank you, Your
All
Honor.
right, you're welcome. Ellen Clark? Mr. Clark, you're before the court today for count 1, felony battery, and count 2, criminal mischief. I do find probable cause as to both counts. I'll hear from the parties as to bond.
Your Honor, I'm going to be requesting a $2,500 bond on count 1 and a no victim contact. It's a bit of a difficult situation. This location where this occurred is an ALF. That we necessarily have the resources at first appearance to deal with it the best way possible. That's why I'm just making a bond request and order requesting no victim contact.
Okay. Yes, Mr. Hill.
Thank you, Judge. In speaking with Mr. Clark, he is 32 years of age. He's been living in Florida approximately 13 years. I know the state asked for a $2,500 bond. In discussing his finances, he indicated that $250 made payable to a bonds company would be impossible for him to post. He is currently trying to get himself back in school. He's an author. He likes to write, and he's trying to save up for school as well. With the court, and I was told that I believe that this dispute is between roommates, according to Mr. Clark. Would the court consider a $1,000 bond in lieu of a $2,500 bond? He indicated at most he could afford $100.
It looks like there needs to be further investigation. I don't know the reason. It's a ALF facility that he was at, that he, with his roommate, so I don't know what the circumstances are. So at this time, I'm going to impose the bond of $1,500, and if there is something else that needs to be investigated and be brought back to the court's attention, I'll be happy to listen to that.
Does that include?
Thank you, Judge.
No
So
contact,
Thank
Your
no,
Honor?
so no victim contact until further order of the court. Mr. Clark, did you hear that? Mr. Clark, no victim contact. So no contact with this person that's alleged in this probable cause affidavit.
I would like, before I pay it, I'm gonna have to move it into the room.
He's just indicating the same thing you are, that he wants to move and not be around that individual.
Okay, all right.
Thank you.
All right, good luck, sir. Do you have a Dalvon president? This was a 24-hour perfection. Does anyone have Dalvon?
Not the main, no.
It's gonna be in the afternoon? Okay. The clerk brought me the paperwork, so,
Because he wasn't on the docket, I brought it to the clerk's attention, and I thanked the clerk.
oh,
Because you'd given the state 24 hours from yesterday morning.
yes.
I mean, just to comply with the 24 hours.
MD.
It was. Right, there was no test.
I remember this one.
And Your Honor, just to advise the court, because the supplemental report I gave you does not have Mr. President's name on it, but you can, it has the same offense report number from the
Judge,
original
the only
PC.
thing that I would ask, just sorry to interrupt. I mean, he's being held no bond for VOP, and he also has an out-of-county hold, so he's going to be in custody. You know, it appears the state has met their requirement. I guess the court's going to make that determination, but can we reset this just to allow him to appear? He's not going to be released.
And Your Honor, and I'm fine with that. I just wanted to
Okay.
give Your Honor the report just to
All right.
be above
And,
water.
if we
Whether
can
it's
bring
this
him on for the,
afternoon or-
if he can be brought on for the afternoon, I do. All right? Okay. Thank you, everyone.
Thank you.
Yeah,
Wanna
I'm-
come-